Okay, so I think we can start. It's almost 8 o'clock. Good evening, everyone. As you now all know, we're here to have a conversation with Professor Jeremy Sharpe on adverse inferences and international arbitration. This is part of a series of events about the Brazilian arbitration competition, and it's hosted by the University of São Paulo's arbitration group. I was kindly invited by the USP group to moderate this event, but our special guest here today is Jeremy Sharpe, and I thank you for your kind acceptance to talk to us today. Just for a quick introduction, my name is Julia Cavalieri. I'm a student at University of São Paulo. I'm also a member of USP's team for this Brazilian arbitration moot this year. And I'm currently working on a graduation thesis that has the adverse inference theme as its main focus. As for Jeremy Sharpe, he's now an independent arbitrator. He was a partner in Sherman & Sterling's. He has served as Chief of Investment Arbitration in the Office of the Legal Advisor at the U.S. Department of State. He has also clerked at the Iran-U.S. Claims Tribunal, has a JD from NYU, LLM from Harvard. As you all know, he's the author of the Drawing Adverse Inferences from the Non-Production of Evidence, the Bible of Adverse Inference that I believe every student this year that takes part in the Brazilian arbitration moot is using. So I did not speak only in my name, but as for all the students in Brazil, I thank you, Jeremy, for agreeing to talk to us today.
Well, thank you very much, Julia, for the introduction, which was very kind. It's a real pleasure to be here, and thanks to Fernanda for organizing. And I'm very delighted to hear that students are finding the topic of adverse inferences interesting, and also that this article that I wrote some years ago is of some assistance to them in the moot problem. So thank you for having me.
Thank you. So as we agreed, we have some main issues we would like to discuss with Jeremy today, but during the whole event, you'll all be able to send questions if you want through the YouTube chat. So we'll select the main questions and ask Jeremy in the end. But I think we can begin. So as for our first issue today, the mechanism of adverse inferences is still not broadly known or applied, especially here in Brazilian arbitration. It looks like there is a fear that the drawing of adverse inferences would be a violation to due process. So we would like you to explore this issue a little bit and maybe introducing what exactly is an adverse inference.
Sure. I'm not sure there's a uniform definition, but I think what it is getting at in the understanding of most is that the disputing party, without justification, fails to produce evidence when it's required to produce that evidence, then the tribunal may draw an inference against the interests of that party. I think the underlying assumption is if the tribunal has ordered the production, if the tribunal expects the production of evidence, the party has that evidence in its possession, but it fails to produce, that it has something to hide, and that the tribunal will draw certain inferences from that non-production. It sounds a little bit easier perhaps than it is to apply, because then when you unpack that definition, when does a party have an obligation to produce evidence? Is it only when it's specifically ordered as to that specific evidence? And what happens if the party doesn't provide justifications or sufficient justifications for not producing that evidence? What are the grounds that the tribunal could say, well, we don't expect you to produce in these circumstances? And if the party is deemed to have the evidence and it's deemed that it wasn't justified in producing it, then the tribunal will draw an inference. But what does that mean in practice? Will the party that did not receive the evidence prevail on its claim? Is it just a consideration for the tribunal when it's weighing other direct and circumstantial evidence? So I think there's a broad understanding of what the concept is, but there's a lot of flexibility in how it might be applied in the factual circumstances of any particular case. And the absence of criteria, Julia, I think going to your point, is really what gets at this due process concern. If you're a tribunal and you don't have specific criteria to apply, then you might not either draw the adverse inference or might not be very clear in your reasoning about the effect that the adverse inference may have in ruling for or against a party. The famous arbitrator said adverse inferences aren't the fearsome weapon some lawyers seem to imagine, because most arbitrators would be disturbed at the thought of discharging the burden of proof on the basis of a mere inference. I think there's probably a lot to that. Most arbitrators are concerned about discharging the burden of proof. So I think it's useful to consider what criteria might be involved in drawing an adverse inference, and then if there can be some common understanding of this, then it makes it easier both to apply in practice. Each party can understand what its obligations are and what the consequences are for breach of that obligation. And also, it will just make the process fairer and sort of more transparent for everyone.
Yes, I think maybe a lot of lawyers see the adverse inference as a punishment, but it can also be a way of the tribunal to make the party effectively produce the evidence. Since the arbitral tribunal does not have the empyrean, it's one way of making it actually produce the evidence.
Yeah, I think that's absolutely right, and I suspect the threat of drawing adverse inference is used much more often than the actual adverse inference. That is, an order from the tribunal: we asked you to produce this document, you failed to produce it. If you persist in failing to produce it, the tribunal may draw negative inferences, and that may then encourage the party to produce it. Because any tribunal, I think, from whatever part of the world, would like to have the relevant evidence before it, to have the direct evidence to be able to decide the case on that without having to draw an inference. But as you suggest, the powers of arbitrators have their limits.
Precisely. So going back to the origin of all of your study, could you tell us a little bit of the context of the Iran-U.S. Claims Tribunal and how it was actually the cradle for this mechanism of adverse inferences, or at least its systematization, right?
Yeah, I do think the Iran-U.S. Claims Tribunal is a very interesting model to look at, or tribunal to look at for adverse inferences. Part of it was just the unusual circumstances of the tribunal. It was the product of the Islamic Revolution in Iran. You had a situation where you had tens of thousands of Americans living and working in Iran. And by the summer of 1979, some 45,000 of them fled. And many of them had businesses and investments, and many of them suffered things like expulsions or contract cancellations, expropriations of their property, and other kinds of interference with the management of their business and so forth. And so when these individuals, many of whom brought claims before the Iran-U.S. Claims Tribunal, ended up being more than 3,000 claims, the evidence that they normally would have was sometimes lacking, given the circumstances in which they left. And much of this evidence was either understood to be with the government of Iran or one of its entities, or presumed to be with the government of Iran. And so you had a situation where the claimant would say, I don't have the evidence to support this, but I believe that the respondent does have this evidence. if the respondent doesn't produce it, you should draw adverse inferences. And the tribunal did draw adverse inferences, or at least discuss adverse inferences in the context of a lot of different aspects of the claims. The tribunal itself is a second factor that I think is quite interesting, because you do have this interesting mix of American appointed, Iranian appointed, and third country appointed judges. You had always a common law influence, a civil law and Islamic law influence. And you had a lot of very difficult issues, substantive and procedural. And of course, there's not a lot of guidance for tribunals often in the applicable law or the procedural rules to decide some of these very difficult questions, including questions of evidence. The Iran-U.S. Claims Tribunal applied the UNCITRAL Arbitration Rules 1976 with some minor modifications to make them work for a semi-permanent tribunal. And the 76 UNCITRAL rules don't say anything about adverse inferences, so this is one of the many areas where the tribunal had to fashion some rules. And although they didn't fashion explicit rules on the drawing of adverse inferences, if you look at the jurisprudence, you can see some common approaches, which is what I was trying to distill. And the reason I was able to distill these is a final factor, which is the transparency of the Iran-U.S. Claims Tribunal. I mean, it's only been a few years now that we've had the UNCITRAL rules on transparency in investor-state dispute settlement cases, but the Iran Tribunal was interesting in that from the outset, the tribunal has published the awards, the decisions, and significant orders, and has compiled these in now nearly 40 volumes of the Iran-U.S. Claims Tribunal reports, and they're available online. And this was enormously influential, the transparency, the publication, in helping develop this area of law in substance and procedure. So all of these factors combine to make the jurisprudence of the Iran-U.S. Claims Tribunal both accessible and interesting to look at when I was trying to distill these criteria for drawing adverse inferences from the non-production of evidence.
Well, that's really interesting. We see, right, sometimes in the rules of the chambers, the UNCITRAL rules, but also this year's arbitration Brazilian competition, we have the application of the IBA rules, and the IBA also provide the adverse inference, but they don't determine the requirements for its protection. That's precisely why we go to doctrine and jurisprudence, in our case to your article, to find those requirements. But it's really interesting to see how the tribunal itself constructed a system to go over these requirements and have some kind of pattern.
Yeah, as you say, that even when parties have come together, groups have come together to try to codify, so to say, even though in soft law, these rules of evidence, you still see a lot of flexibility. And part of it is by design. I mean, the IBA committee wants to provide guidelines and template for rules that are available to parties from all different legal, linguistic, cultural backgrounds and so forth. And so they don't want to be overly prescriptive, but then the consequence of that is sometimes you're left wondering what the content of the rule means in practice.
Yes. Well, now going over the requirements you systematized in your article. First of all, how strict do you consider them to be? I mean, do you believe it would be possible to loosen a little bit one of the requirements and still be able to apply the adverse inference?
I think that's a good question. I think there's a degree of flexibility probably in all the rules. Some of them are probably, or the criteria, some of them are probably harder to loosen. For instance, if a party did not know of its obligation to produce evidence, if it either hadn't been ordered to produce that evidence, or if there weren't some other reason for the party to understand the obligation to produce, and the tribunal ruled against that party because of its non-production, I think that could give rise to some really serious due process concerns, either by an annulment committee or a national court looking at set-aside. I don't think we see that in practice, but of course it's a risk. I suppose maybe similarly, if the evidence is not available to the party and the tribunal concludes that is to say, the tribunal says, okay, respondent, for instance, you've said you don't have these documents, and we believe that you don't have these documents. You didn't destroy these documents, you were negligent in your record keeping. Then I think you're probably not going to draw an adverse inference from the non-production of that evidence. Now, again, the tribunal may say you should have had this evidence, or we're not convinced that you don't have it, or you didn't search hard enough for it. But if the tribunal concludes the party doesn't have it, I think that's probably the end of the story for adverse inferences. Maybe looking at another criteria, I do think tribunals want to have the direct evidence before them. And if the tribunal concludes that the party seeking the adverse inference really hasn't put forward all of the relevant evidence it has or should have on this point, it's probably not going to be inclined to punish the other side by not putting forward the evidence that it has or is expected to have in its possession or draw adverse inferences. So I think there's probably a little bit of flexibility there, but again, tribunals like to see parties comply with their obligations to put forward the evidence to make their own cases and not try to foist onto the other party the obligation to produce evidence to help the other side make its claim or defense.
It does not shift in the burden of proof, right? It's precisely that.
Exactly, that the rules are clear, that each party bears the burden of proving its claim or defense, and tribunals expect parties to produce the evidence available to them to make their cases. And so I think there's perhaps a little bit of room there, but I wouldn't be so surprised to see tribunals declining to draw adverse inferences where they think the other side just really hasn't done a good job of marshalling their own evidence. Maybe for the other criteria, the evidence sought must be reasonable, consistent with facts in the record, and logically related to the likely nature of evidence withheld. There's just a lot of flexibility, I think, in those terms. So when we talk about loosening the standard, I'm not sure that the standard necessarily needs to be loosened for different tribunals to approach this issue differently and say, well, actually, the evidence that you have sought is not reasonable, or it's not logically related in this way or that way. So I wouldn't be surprised to see circumstances where this criteria could have a lot of different interpretations by different tribunals. And I would probably put the final criterion in that same category about making a prima facie case, because to make a prima facie case is going to be differently understood by different tribunals based on what they expect the parties to have produced in the first instance.
Yes, that's precisely one of the main issues of this year's moot, Brazilian arbitration moot. We discuss precisely that the party has to have created a prima facie case. And so specifically about this requirement, how should we interpret it? I understand it goes from tribunal to tribunal, but in your opinion, in what level should we interpret this requirement?
I think there are different components of a prima facie case, things that, for instance, the Iran-U.S. Claims Tribunal have looked to. The first one is the tribunal wants the party seeking an adverse inference to put forward reasonably consistent evidence. And I think consistency probably for a lot of tribunals has two aspects. There's an internal consistency. The party should make its case in a consistent fashion. witness testimony should be consistent with the documentary evidence. For instance, documents should be consistent with one another. If the tribunal has a sense that the party hasn't even put forward a consistent claim internally as within that case, I think the tribunal will treat it with a degree of skepticism and may not find that a prima facie case has been made. At the same time, there's kind of an external consistency element to this as well. The case could be internally consistent, but if it just doesn't make sense in light of how a tribunal might think these parties should operate in normal commercial operations, or it just doesn't jibe with the arbitrator's understanding of commercial practice, I think there's just going to be a degree of skepticism about this and whether the case actually makes sense to the tribunal and whether they have confidence that actually a prima facie case has been established. I suppose the second criterion is a degree of completeness in the evidence. Going back to the earlier point about making sure that the party seeking the adverse inference has put forward the evidence in its possession, the tribunal does expect the parties to come forward with evidence in its possession to make its case, to make its claim, or to make its defense. And if there are just big gaps in the evidence, if it's not complete, if the kinds of documentary or testimonial evidence that the arbitrators would expect to see is simply not there in a complete form, reasonably complete form, then again, I think the tribunal will say, look, we're just not going to conclude that you've established your claim sufficiently on a prima facie basis so as to draw a negative inference from the non-production of evidence by the other party. So I think completeness is a second criterion, and perhaps somewhat related, a third criterion would just be a degree of formality. We see this with some of the claims at the Iran-U.S. Claims Tribunal, where the tribunal was just concerned. If you have a large claim by sophisticated parties and the documents just don't correspond to the nature of the purported relationships in terms of the contracts or supporting evidence, the documents are informal, I think the tribunal is just going to be skeptical that this is really the kind of claim that they could have confidence in, especially when they're being asked to perhaps rule in favor of that party on the basis of an adverse inference. So I don't know that these will play out the same way in every case, but these are some of the factors that a tribunal might look at to try to ascertain whether a prima facie case has been made sufficient to demand that the other party produce documents which could lead to adverse inferences if they're not produced.
This is curious because in our case, the other evidence that we have that would corroborate the adverse inference would be a WhatsApp conversation. So we argue that it is extremely informal. It has not any kind of relevance. So that's precisely what we argue. But we've been receiving some questions here that relate specifically to the case. So I'll bring it to you. Well, the IBA rules specifically relate the possibility when talking about the protection of evidence of asking a party to produce a document to the concepts of possession, custody, or control. So do you believe this specifically affects the requirement that the document is in the possession of a party in any way? Do you think we can apply these 3 degrees also to the adverse inference?
I would think so. I think, first of all, in the case of many arbitrations, and as with your moot, the parties have agreed either to apply or to be guided by the IBA rules, and the tribunal will seek to make sense of the IBA rules as a whole. And so the tribunal probably will look, when they're seeking to apply a criteria, whether it's a criterion, whether it's formal or just at the back of their mind, does this party actually have the document that's being requested? Should it have? So not just in its custody or possession, but perhaps in its control, that is, an affiliate has it or some other entity within the corporate chain has it? Is there some way that the party should be expected to keep this as the part of their ordinary record keeping? Would it be negligent for the party not to have had it? So I do think that the tribunals would precisely look to possession, custody, and control as part of this prong of determining whether the party should have the evidence in the first instance, and what to do when the party comes back and says, well, we don't actually have this document, this, say, WhatsApp chat, or whatever it might be.
Yes, in our case, the companies are part of the company that actually has possession of the document integrates the same group of companies as the one being requested to produce the evidence, but it argues that it doesn't have control or access to the document. But some people are arguing that maybe the requested party can ask its controller, that is part of the same group of companies, to produce the evidence. In that case, if the arbitral tribunal requests the document to be produced by a third party, the controller is not a part of the arbitration, do you think an adverse inference can be made against the party to the arbitration? So the third party doesn't produce, but the inference is drawn against the party.
Yeah, it's an interesting question. I think a tribunal might be concerned, given that it doesn't have control over that party, and it would be difficult to penalize a party for the non-production of evidence by another party if it doesn't actually have any control or legal influence over that third party. There may be circumstances where a tribunal feels that there's some kind of there's some sort of influence by the requested party over the third party not to produce. There could be some interesting instances where a tribunal might not be fully confident that the third party has declined to produce it in good faith and penalize the requested party. But I mean, in principle, I think the tribunal would probably be concerned about drawing an adverse inference from the non-production by a third party.
Yeah, I understand. And also, there is a discussion about the duty to apply your best efforts to get access to that evidence. I believe it is relevant to determine whether the party has or should have access to the document. But do you think this criteria of best efforts would be compatible with the adverse inference? So you can punish a party that applied its best efforts and could not gain access to the document with the drawing of adverse inferences.
I suppose there could be circumstances. A tribunal may say, I understand your concerns that formally you don't have possession, custody, or control over these documents, and formally you don't have the authority to tell this third party to produce. But we've requested that the third party produce it, and we request that you exercise your best efforts to seek to have that third party produce those documents. If the tribunal is convinced that best efforts were not applied, then perhaps an adverse inference might be warranted. If best efforts are applied, again, I think tribunals are a little bit concerned about the due process concerns of penalizing a party for failure to produce documents that honestly are not in its possession, custody, or control. So I think most tribunals would be quite hesitant in these circumstances to push it too far. But it's certainly an interesting issue.
Could be an issue when thinking about the due process. The party didn't have access. Okay, so let me see the other questions we received here. Okay, the IBA rules also establish that the adverse inference may be drawn if the party does not have a plausible justification for not presenting the evidence. Do you think this can be considered a specific requirement for the drawing of adverse inference?
I do think justification is inherent in this entire exercise, that tribunals in every case will look at the justification. One party has an obligation to make its case or defense. and to adduce the evidence sufficient to carry its burden. It is then saying, I don't have the evidence, I believe that the other party has it, I'm requesting that you order that party to produce it, and if they fail to produce it, to draw negative inferences. And in every case, the tribunal will say, fail to produce it without justification. And justification could be, I never had that document, I don't have it now, it was destroyed in the ordinary course of our business practices, for instance, that are consistent with our industry practices, or whatever justification it might be that the tribunal would conclude are appropriate for that party, for the industry, for the circumstances, whatever criteria the tribunal might apply, but justification is inherent in the exercise. If the party that is requested to produce the evidence simply doesn't have it and has a good justification that is accepted by the tribunal, again, I think that's probably the end of the matter in most circumstances.
Yes, precisely. And also, do you think an arbitral tribunal may draw an adverse inference at any point of the arbitration, or do you think it should wait for a certain procedural moment? Because in our case, the party requests really at the beginning of the arbitration procedure. So what do you think about it?
I think tribunals are probably not minded in general to draw adverse inferences too early, any earlier than they're absolutely required to do. Instead, what they might be inclined to do is to say, we understand this issue to be of relevance and materiality for the disposition of this case. We understand this evidence to be necessary and that it's not available to the party seeking a negative inference, but is available to you. We've requested that you produce it. You've declined thus far, and you should be aware that the tribunal may draw adverse inferences from the non-production, because the evidence may come through some other route. For instance, let's say the claimant is seeking to obtain that evidence through some third-party disclosure mechanisms in the United States, like 28 U.S.C. 1782, or the issue actually becomes superseded and is no longer relevant, or the arbitration takes a turn that prioritizes some issues over others. So I don't think a tribunal would want to get ahead of itself in actually drawing a negative inference until it absolutely has to render the relevant decision or award. But still, I think signposting is very important for tribunals for due process. That is to say, we are in a situation where the party that has the burden of proof is seeking to obtain evidence from the other party in order for the requesting party to make its case, and the requested party has to understand the consequences of not producing the evidence. Transparency is very important. If the requested party has no idea that it has been requested to or is expected to produce this evidence, and then ends up losing the arbitration because of its non-production, again, there could be very serious due process concerns on annulment or set aside. And just the fairness of the process as well. This is not just about a fear that the award will be set aside, but ensuring that the parties can reasonably make their claims and defenses in a fair manner, and that this process works smoothly and to the benefit of both parties. So transparency from the tribunal, I think, at all stages is very important.
Well, so the establishment of the possibility of drawing an adverse inference could be made at any time, but usually the tribunal waits to the last minute to effectively apply the adverse inference, right? So in our case, it's pretty much it, because the party purports it depends on this evidence and consequently on the adverse inference to make its whole case. So I believe the tribunal would only be able at this time to reinforce its possibility of drawing an adverse inference, but would have to leave it to the last part of the procedure to effectively draw an adverse inference.
Yeah, I think that's at least generally how tribunals have handled it.
So, and also, can an arbitral tribunal draw an adverse inference that is not exactly the inference requested by the parties, so reach another conclusion, maybe?
That's interesting. I think generally tribunals are quite hesitant to, at least if we think about the role of adverse inference of closing the evidential gap. That is to say, the claimant has produced, say, prima facie evidence, and the respondent failed to produce evidence that would allow the claimant to satisfy its burden of proof. And so there's this delta, there's this gap, an evidential gap that the inference is serving. But the claimant has specifically requested evidence that it needs to close that gap, and the respondent, without justification, has failed to produce that evidence that would help the claimant close that gap. Now, if the tribunal were to insert a different inference between the prima facie evidence produced and the evidence required for the claimant to meet its burden, again, I think there could be some due process concerns. I think tribunals are fairly clear that the parties seeking an adverse inference should specify what the inference is that they actually want the tribunal to draw. That is to say, the respondent has the board minutes of such and such date which show that they made this decision. And by failing to produce that, they have failed to allow the arbitral tribunal to see the following consequence in our case. And then the tribunal can then place that requested inference into their analysis for the drawing of adverse inferences and the disposition of the case, and everyone knows what purpose the inference is serving. To introduce a new inference in there, it could be, I think, under certain circumstances, problematic for the fairness and due process of the arbitration.
And I think this relates also to another question that we have, and that connects again to the Brazilian arbitration moot case.
Sorry, it's bedtime here.
No problem at all. So I think it connects with another question we received, and it's linked to the Brazilian arbitration moots case. So can an adverse inference be drawn if the party that requests it is not so sure about the content of the evidence, the document? So it has established precisely the conclusion it wants to reach, but it doesn't know the content of the document.
That's an interesting question. So in inference, a claimant may request inference, for instance, that I believe this evidence would establish the following: the respondent has failed to produce it. Its failure to produce without justification shows that it has something to hide, and the inference that I'm seeking is logically related to this matter. I suppose there could be circumstances where a tribunal would find that acceptable. Certainly, it would be better if the party has more complete understanding of what the evidence says, but that's not always possible, I suppose, in certain circumstances. You just have an understanding that, for instance, in the ordinary course, the board would have met on such and such a date, and they must have taken a decision with respect to the project because this is referenced in correspondence 2 weeks later, but we don't know what the board decision was. I suppose this goes back to the arbitrator's broader understanding of the nature of the case, and has the claimant otherwise put forward a consistent case internally and externally? Is the evidence otherwise reasonably complete, and is the evidence otherwise reasonably formal? If the claimant has made a prima facie case and the evidence is compelling, both documentary and testimonial, then I think a tribunal is probably a lot more inclined to give it the benefit of the doubt and to put more of an onus on the requested party to produce evidence, even though the claimant or the party seeking an inference hasn't been able to articulate precisely what that missing evidence might state.
So in conclusion, it must be never a shot in the dark, right?
Yes. I do think that's absolutely. If it seems too far off the mark, tribunal just wouldn't feel very uncomfortable ruling in favor of a party that has failed to produce enough evidence to carry its burden of proof.
Precisely. Well, I think our conversation was really helpful. We've gone over all the questions we received. So I would like to once again thank you, Jeremy, for you kindly agreeing to talk to us. I believe I speak not only on my behalf, but of every student, hundreds of students actually in Brazil. It has been really helpful. We're really using your article as a Bible on adverse inference. So thank you once again.
Thank you, Julia. It was a great pleasure to be here. I hope that conversation was useful. Good luck to you and to all of the students who are participating in the MOOCs, and I look forward to seeing how the competition turns out. Thank you again.
Thank you. Good evening, everyone.